have, it's a cup, they're going to need to fill that out and sign it, and go back there and sign it them. I don't know if they can fill it out and sign it up here.
Judge, they're going to be.
I know, yeah. Oh, okay. The village change, okay, great, thanks. Do you have,
For you, Ms. Dawson, rather than Judge. Thank you. And if we have people addressing the board from the podium.
we are on the record in case 703-479, State versus Nathaniel Crockett and John Armstrong. On behalf of Mr. Crockett is Mr. Richardson, Buckley, and Margolis. And on behalf of Mr. Armstrong is Mr. Spelksy and Mr. Ramsey. On behalf of the state of Ohio is Mr. Cleveland and Ms. Dawes. Now, we're here for sentencing today. Both parties have waived pre-sentence investigation. Defendants were found guilty of 2 counts, each count 7, tampering with evidence, felony of the 3rd degree, no firearm specification, and count 8, arson, felony of the 4th degree, no firearm specification. As I explained to you before we got started with the trial, and I gave you informed you of your maximum penalties, included in that was a duty to register as an arson offender. You have that document in front of you. I'm going to read it to you, make sure that you understand it. You have been convicted of, or plead guilty to, in this case convicted, of an arson offense. Arson-related offense is defined in ORC 2909.13. You're required to register in person with the sheriff of the county in which you establish residency within 10 days of being released from incarceration or within 10 days of your sentencing hearing if not sentenced to incarceration. You're required to provide to the sheriff certain information, including your social security number, your full name and any alias you use, your residence address, information regarding the offense of which you were convicted, a description of any scars, tattoos, or other distinguishing marks on your person, the name and address of any place where you are employed or attend school, any driver's license number, commercial driver's license number, or state identification card number issued to you, the license plate of each vehicle owned or operated by you or registered in your name, the vehicle identification number, and a description of the vehicle must also be provided to the sheriff. You're required to provide to the sheriff fingerprints and palm prints. The sheriff will also obtain a photograph of you at the time of registration. You're required to remit or provide a registration fee of $50 to the sheriff unless the fee is waived. After the date of initial registration, you are required to register annually. You must update and or amend any of the information described above that has changed and provide any additional information requested at the county sheriff's office within 10 days of the anniversary of the calendar date on which you initially registered. If you are registering in a different county than your prior registration, you must provide written notice of your change of address to the sheriff with whom you previously registered. You're required to pay a registration fee of $25 to the sheriff. You're required to comply with all the above described requirements until your death unless sentencing court determines otherwise. So you're going to fill out the top portion. I'll fill out the conviction ORC with the assistance. Your attorneys may do so as well. Your expected residence address, your social security number, and the county in which you intend to reside. Do you understand failure to register or failure to verify residence at the specified times will result in criminal prosecution? Do you understand that, Mr. Crockett?
Yes.
And Mr. Armstrong?
Yes, ma'am.
Okay. Please go over that with your attorneys, and if you understand it, please fill it out and sign it.
We have this filled out, Your Honor. Do you want me to bring it to you?
Yes, thank you.
Thank you.
Mr. Carter didn't fill out a social security number.
Sorry about that. What is your search
Okay, and both of you have signed this acknowledging that you understand your obligation to register as arson offenders. All right. Moving on, we had not necessarily talked about this prior, but I wanted to discuss the issue of merger between count 8 and count 7. What is the state's position regarding merger?
Thank you, Your Honor. May it please the court, I have a couple of cases here I can provide to the court and defense, but we believe that these counts would not merge for purposes of sentencing. With respect to the victims, there's a separate victim on the arson count, whereas for the tampering with evidence, the state of Ohio would be the listed victim on that count, as essentially the tampering would damage or impair a investigation. So I'll cite to State v. Miller, that is a 5th District case, 2016, Ohio 2673, and the court in that case again states, and I'm going to quote, "The harm caused by the arson which destroyed Thompson's vehicle was caused to Thompson and or her estate, while the harm caused by the tampering with evidence charge related to the body was caused to the state through the hampering of the investigative process."
Related to the body, did you say?
Related to the body in that case, Judge, but again, in State v. Hare, that's 6th District, 2023, Ohio 2422. Courts, and I'm going to quote, "Courts have held that arson and tampering do not merge because there is a harm to the owner of the thing burned and a harm to the state in the loss of evidence." And it cites other cases out of the 5th District. So, based on that, Judge, and arguably for the facts of our case here, the tampering with evidence constitutes a further course of conduct, namely that vehicle traveling from Warren up into Cuyahoga County and the movement of that vehicle through the city of Cleveland to where it was finally burned on Sherwood Road. So I think for all of that, Judge, there is not a basis for merger, and we'd argue, based on the facts and the law here, that the two counts would not merge. Thank you.
So are you arguing that the case law states that there's two separate victims, being the state and the owner of the vehicle, or are you arguing, which I'm not quite sure I'm with you there, that the traveling of the car was a separate act than the burning of the car?
I would argue them in tandem, Judge, and we've seen, I'd argue, parallels in other counts. Discharge of a roadway, the public is the victim in that case. So we have other counts in the law where it's either the public or the state as a victim, which is separate and apart from the actual owner of the property that was damaged. But we also, in this case, have other conduct related to the vehicle that I believe could constitute that tampering with evidence, apart from just the simple act of lighting it on fire.
So You made an analogy to case law regarding discharging a firearm on or near prohibited premises,
Correct, Judge.
but that does actually merge with felonious assault.
Your Honor, Your Honor, so my belief was that
Oh, I'm
that
sorry,
count.
it does, State v. Carzell, State v. Johnson, the A3, the A3 statute does not merge with felonious assault.
And that was my recollection, Judge, is that the public is the victim on that count, which would be separate and apart from a felonious assault, say. And that's why the firearm specifications in those cases would not merge as the separate victims.
All right, defense position.
Thank you, Your Honor. I think that we would be misstating the law if I sat here and attempted to argue, Your Honor, that as a technical matter, these two offenses merged. I don't believe they do, frankly, in light of the victims, but I would just want the court to take note of the fact that I believe, based on the evidence that was admitted at trial and the argument advanced by the state of Ohio in its summation, the same conduct which caused the finding of guilt on the arson was the same conduct that caused the jury to find guilt on tampering with evidence. So it's not a legal or technical merger, but I would ask you to just note that I believe it's the same conduct that resulted in the convictions.
I would agree that it's the same conduct based upon the state's theory and, frankly, the jury's belief that this was an arson in furtherance of impeding the investigation for murder. And so the conduct is the same, but if he's telling me, and nobody's contesting the fact that there's case law that notates separate victims, that it's not, that does not merge, then that's the case law. And so that's my finding, essentially. I do believe that it's the same conduct. I know that they've made that argument that the tampering with evidence can also be thought of as moving the vehicle from one place to the other. There's, on behalf of Mr. Armstrong.
If I could just add one thing, Judge. Regarding the same behavior, if you look at the bill of particulars for count 7 and count 8, they list the exact same behavior. They list the tampering occurring on Sherwood Road.
Well, I agree with you. I agree with you as to the conduct, but what I'm saying is that if the case law, so, for example, felonious assault, 2 victims, same shot,
Right.
it counts as 2 different.
I agree.
Yeah.
Right. I agree.
All right.
Your Honor, we would agree with that as well, but the methodology for the tampering was the commission of the arson, so like everybody is saying, it's the same acts.
I agree.
But we do understand that separate victims, we do understand.
Okay, all right. Then, for the purpose of sentencing, they will not merge. Okay, all right, on behalf of the state.
Thank you, Your Honor. And, Your Honor, if I may just have a moment. Thank you, Your Honor. May it please the court. So I'm not going to go through a factual rendition of the trial. We're here in trial for about 2 weeks, and the court saw the evidence presented in this case. With respect to the tampering and the arson, the question we now have is what the appropriate sentence is for these 2 defendants on those counts. I'd argue, Judge, that prison, first of all, is appropriate for both defendants, given their criminal history and the specific facts of what occurred in this case. With respect to defendant John Armstrong, he has a 1995 conviction for aggravated robbery and manslaughter with a firearm specification. He has a 2005 conviction for kidnapping and aggravated robbery, again with a firearm. And during the course of the attempted arrest in this case, the evidence was not presented to the jury, but as the court is aware, Mr. Armstrong shot at U.S. Marshals that were attempting to effect the murder warrant out of the city of East Cleveland. So based on the criminal history and the facts of the evidence here in this case, I think prison is appropriate on both these counts for Mr. Armstrong in particular, and I suggest to the court that consecutive sentences would be appropriate given both the course of conduct. I'd argue, again, my similar argument with the course of conduct for the tampering, which, if we're going to believe the evidence linking Mr. Armstrong to these crimes, would entail him bringing that vehicle from the city of Warren up into Cuyahoga County, and then that vehicle being burned on Sherwood Road. So I think course of conduct for consecutive sentence findings would be appropriate, and that the fact, based on his prior criminal history, that it's necessary to assure the safety of the public for potentially imposing consecutive sentences on these two counts for defendant Armstrong. With respect to defendant Crockett, he does have prior felony convictions, including a felony failure to comply with lawful police order and a felony to robbery with a firearm specification. I believe both of those occurred in 2020. He did go to prison on those cases, Judge.
When was he released? Do you know when he was released from prison?
So he was sentenced in 2020. He was released, I believe, in 2024. I believe it was a 4-year prison sentence imposed by Judge Michael Rousseau.
Was he on PRC at the time?
At the time of this offense, I don't believe so, Judge.
If I may, just quickly to help Chad as well, Your Honor. Mr. Crockett said he was released in 2023, no PRC.
So there's not a basis for a in custody charge with respect to this case, Judge, but that prior criminal history, as we'd argue with Mr. Armstrong, applies to Mr. Crockett as well. I believe that the courts can and should impose consecutive sentences on these two counts, given Mr. Crockett's prior criminal history, the facts of these cases here, and the need to protect the public from future offenses by that offender. And, Your Honor, with respect to the victim's family, they are present here in court today. I did speak with them, and they simply wanted to relay to the court that they hope that justice be done in the fashion that the court can do so with the charges that are here before it today. We understand that Mr. Armstrong in particular has other things he has to go answer for in other courts. With respect to what this court can do, we'd ask for a prison sentence in this case, and that the court consider consecutive sentences as we feel they're appropriate. Thank you.
Who would like to go first on behalf of the defense?
Thank you, Your Honor. Anytime the court presides over a jury trial, particularly one of the duration of this one, there's, I don't think, a whole lot to add to what the court knows. I suppose, I believe an interpretation of the evidence that was admitted was that Mr. Crockett never left the Cleveland area. The jury determined his guilt with respect to these two offenses. He has been to prison, I believe, once before. He does have family support. They're here in the courtroom. He, I believe, is still young and has redemption certainly within his reach. I feel confident that, again, his conduct was very limited in this incident. The same conduct, though not merge-worthy, the same conduct represented the basis for both convictions. I don't think there are findings that could be made that would justify consecutive prison terms for Mr. Crockett. He's been in jail for 14 months, Your Honor, and I believe that, I've always believed that time in the county jail is worth in excess of its day-to-day quantity, because the conditions in the county jail are extremely difficult to endure, and I would ask you to take that into account in imposing sentence.
Mr. Buckley, anything to add?
No, Your Honor.
On behalf of Mr. Armstrong.
Your Honor, we understand Mr. Armstrong has other issues. And we would ask the court to take into consideration his family present in the back of the courtroom as well. He's been in the county jail for 11 months, facing the most serious charges that one can face, which he was exonerated of.
Well, I mean, he was found not guilty.
No, not guilty, I'm sorry.
Back on, your voir dire.
Absolutely, Judge, that's not correct.
And I'll tell you, the general consensus of the jury was that there was just not enough evidence, but
Understand. He was found not guilty.
likelihood of this is
Thank you, Judge.
understood.
So we ask to take that into consideration. We'd ask for appellate counsel for this matter. We advise him not to address the court.
All right, anything?
No, thank you, Judge.
Okay. All right, so I only consider what's been presented and what the jury has found the defendants guilty of. And so the court has the obligation to consider the purposes and principles of sentencing under the Ohio Revised Code, which seek to punish and rehabilitate the offenders as well as protect the public from future crime by the offenders. I also need to consider the seriousness and recidivism factors relevant to the offense and the offender and the need for deterrence, incapacitation, rehabilitation, and restitution. And the court must use the minimum sanctions that the court determines would accomplish the purposes without imposing an unnecessary burden on state or government resources. So, you know, we get tampering with evidence charges all the time. And I have to determine whether or not this is one of the more seriousness of the offenses. Tampering with evidence comes in many forms. It's maybe destroying a document, throwing a firearm. In this case, it was in particular to burn out a vehicle when, and again, as the jury found, when an investigation was likely to commence or commencing. This was a calculated effort and coordinated effort by the both of them. Their phones proved that they were both together. You can see Mr. Crockett on video several times at least 2 times throughout this incident this night. They tracked each other's phones. They FaceTimed together throughout the time that they brought this car from one place to the next and then burned it out in East Cleveland, which unfortunately they thought was a good place to be a dumping ground. And that's what they did. I have to look at whether or not their conduct is more serious or less serious. I'm finding that it is more serious than the offenses that generally come before us. I also have to look at their recidivism and whether or not the recidivism is more or less likely. For both defendants, I'm finding that it is more likely that they would recidivize because they already have. Particularly, I believe you said that the robbery case that Mr. Crockett had, was that firearm specification of that?
There was, Judge.
So both offenders have used firearms in past convictions. Mr. Armstrong himself has been held accountable for the death of the person. It was an involuntary manslaughter with a firearm specification. Have been to prison and in Mr. Crockett's case shortly after committed a new crime. So I am finding that prison is appropriate for both defendants in this case, and they are not amenable to community control sanctions. For a felony of the 4th degree, the maximum is 18 months, and for the felony of the 3rd degree is 36 months in prison. Again, this was not something where somebody made a snap decision to try to hide some drugs from the police when they were being arrested, ingest it quickly, throw it under a car like we usually see. This was the most serious form of the offense in burning out somebody's vehicle, depriving them of their property, and also impeding the efforts of law enforcement to solve murder. And the jury made that very clear. So, having considered that, I'm going to sentence both defendants, Mr. Crockett, 18 months on the arson and 36 months on the tampering with evidence, and same for Mr. Armstrong, 18 months on the felony of the 4th degree. and 36 months on the felony of the third degree. For both defendants, I'm imposing consecutive prison terms, finding that consecutive terms are necessary to punish the offender and protect the public from future crime. The consecutive sentences are not proportionate to the seriousness of both of their conducts and to the danger that they pose to the public. Both defenders' criminal history demonstrates that consecutive sentences are necessary to protect the public from future crime by each defendant pursuant to their criminal history. And the harm caused was so great or unusual that no single prison term would adequately reflect the seriousness of the conduct. The sentences are not disproportionate, again, to the seriousness of the conduct and the danger that you pose to the public. The investigation, as the jury found, was severely impeded in solving this crime, and a person lost their vehicle. It was burned out beyond recognition. They could barely get the VIN number, and they had to get it off of the engine. It was a calculated crime. Went, dumped out the water of the gallon of water, filled it up, and then went to a place that you believed was a good place to dump in East Cleveland and burned out the vehicle. That is my finding. There's also, I need to inform you of your post-release control obligations for the felony of the third and fourth degree. It's 2 years discretionary at the discretion of the parole board. Upon your release, they may place you on supervision. If they do and you violate any of the terms and conditions of post-release control, you can be sent back to prison for 1/2 of any sentence that I give you, or up to 9 months for any single violation. You are also ordered to pay back the amount of investigation related to the arson. Do you have that figure?
Your Honor, I don't have that number handy.
It is part of the sentence.
Okay, thank you, Judge.
The defendant both defendants have acknowledged their duty to register as an arson offender, and I'm ordering that you do so. Defendant Armstrong has 336 days of jail time credit. Defendant Crockett has 418 days of jail time credit. Anything else for the record?
Couple of things, Judge. Could you appoint appellate counsel for them as well? And regarding the registration for arson, the court has a choice to make it a lifetime registration or a 10-year registration. We'd ask you to make it a 10-year registration.
Are there any particular factors to consider one way or the other? I don't recall that in particular. I mean, again, I've already made a finding that this is one of the more serious forms of the offense, aside from arson of the home that would relate to the death of an individual, causing the death of an individual.
May I just have one moment?
Sure. While you're doing that, I'm going to read to you your appellate rights overview. You have the right to appeal your case within 30 days after the filing of the court sentencing entry. If you are unable to pay for the cost of the transcript, the record, and all relevant documents prior to the appeal, they will be provided to you without cost. If you are unable to pay for an appeal, you are entitled to have a notice of appeal filed without the payment of a filing fee. If you are unable to obtain counsel for an appeal, counsel will be appointed for you at no cost. Do you understand these rights, Mr. Crockett?
Yes.
And Mr. Armstrong?
Yes.
And remind me, were you appointed for Mr. Armstrong or retained?
We were appointed, Your Honor.
All right, and I'll appoint separate counsel for you as well. I'll put that whoever that is in the journal entry.
Thank you.
Thank you, Judge.
Your Honor, thank you. May it please the court. So, looking at the statute indicates that the court may limit a offender's duty to re-register to not less than 10 years if the court receives a request from the prosecutor and the investigating agency to consider limiting that registration period. So I think that this is not one of those cases, Judge, where we'd be making that request of the court. So I believe whatever the de facto registration time frame would be is not less than 10 years. Thank you.
And They also have the ability to apply for it to be terminated, correct?
Correct, Judge.
Okay. The statute, is my understanding, is that this is a lifetime registration unless and until it's applied for it to be terminated after 10 years, correct?
Correct, Judge.
Okay, all right. And that's what I'll do. I'll post that lifetime registration, and after 10 years, they're able to apply for it to be terminated. Anything else for the record?
I just would like to put an objection on the record to preserve the issue, Your Honor, to imposition of the consecutive sentences.
Would the court consider waiving fines and court costs as well, as they're both indigent?
So all defendants that are indigent and also are going to prison, that's the same thing for all. So I have to determine future ability to pay. And also I have a lot of defendants that do quite a bit of community work service while in prison. I get constant motions with attachments for community work service done while in prison to apply to court costs, and they can certainly use their time to do that as well. Okay? All right. Anything else for the record?
Nothing to have to state, Judge. Thank you.
No, thank you, Your Honor.
No, thank you, Your
All
Honor.
right. You're remanded or be transferred.